Okay. Well, thank you very much for the invitation. Good. Ready to go? Thank you very much, Professor Pasquale, for the kind invitation. And I try to stick in the time frame, although my task is a little bit difficult now. But in any case, I try to squeeze a little bit some of the ideas that I have prepared for you. Also because after this very interesting point of view that you have seen, that you listened to, my point of view and your take, my take, would be that of an international lawyer working with European Union issues, and in particular with issues concerning trade and human rights. Now, I will try to address this long and complex issue in three or two rather main concepts, key concepts. The first one is what the European Union trade policy is about and who makes it, because by the way, I'm talking not only as an academic, but also as a practitioner, since I've been working in particular as a special advisor of the first president of the INTA Committee of the European Parliament, so right after the Lisbon Treaty. So I have some, let's say, insights from the bench on that. And also as a practitioner in the Global Campus of Human Rights in Venice, which is funded by the European Union, and it is, let's say, part of the soft law idea that the European Union has to project human rights in the world. So I'll try to give you a little bit of my insights. Now, we can go quickly on the basics, because I'm sure that you know that the European Union has legal personality, but what does that mean? It means that it can enter international treaties, it can negotiate international treaties, and being a geoeconomic superpower, even though it is a geopolitical little player, but a big geoeconomic superpower, the access to the single market of the European Union is the main, I don't want to use the word weapon, but it makes sense to use it, the main, let's say, offer that the European Union has to give to third countries. The single market is still the biggest market in the world, even though we may have some now competition with the Chinese domestic market, but definitely for a third country perspective, to have a trade agreement with the European Union and have the possibility to have a free trade area, for example, is something extremely interesting because of the consequences. Now, being an international actor, the European Union also is a member of international organizations, in particular the World Trade Organization. Well, you know that human rights are not really on the agenda, right? That's another big discussion to make, but it's not simply there. And which, of course, means that at the multilateral level, this thing is not as straight or mainstreaming as many of us would like it to be. So it turns out to be a bilateral discussion then between the European Union and third countries, which is, let's say, embodied in the specific treaties that the European Union has. The European Union trade policy is therefore something which is extremely relevant, and it must be understood. We now speak up with a 20 years perspective as an evolving regime, which started not as a, let's say, a human rights tool at the beginning, rather was really a trade tool to make, let's say, more growth, economic growth, both inside and outside the European Union. But then after the Lisbon Treaty, which is entered into force in 2009, the things were quite different. And change it. And what makes the big difference is that between the three internal players of the players who shape the European Union trade law, the European Parliament has taken an incredible stance. Incredible because up to that point, nobody really believed that the European Parliament would have taken such an important step as it did and as it does today. Just to give you a little image of the time, before 1990s, I remember Michel Walberg, famous European Union law professor in Brussels, was explaining the European Union to students. I was a student at that time, by saying, you know, the European Union, the European Economic Community at that time, is like a car. So look at it as a car. The engine is the European Commission. The driving part is the European Court of Justice, and where is the European Parliament? Well, that's the backseat. And that was the situation before of course, in the 90s and before the treaty. Now, when the Lisbon Treaty entered into force, the European Parliament became co-legislative, first of all, which is a domestic matter, say, but it also acquired a specific power, which is today extremely important, because when the Commission negotiates a trade treaty with third countries, it receives, of course, the mandate by the Council, but the European Parliament has a voice in that. The European Parliament has a voice, and before it is concluded, formally concluded, lawyers know what I mean, so otherwise we don't have it. Before it's formally concluded, the European Parliament must adopt a specific resolution. Now, in 2009, I was there right at the beginning, first 5 years. The situation was rather clear. The Commission was playing the big part. You know, the strong guys were the European Commission, which were looking at the European Parliament like, oh, these guys do know nothing about trade. I mean, what they discussed about trade, I mean, didn't have any particular competence on that. But if you look at the Treaty of the European Union, in particular the Article 207, the Treaty of the Function of the European Union, you will find that there's a little word that made the difference. This word was the duty of information of the European Commission to the Parliament on the current negotiations. That was the time of the negotiation of the TTIP. You know, was a rather harsh battle, I can say, inside the European Union. And in particular, since institutions are made by the persons who represent them, the person who was the president of the INTA Commission, president of the National Trade Commission inside the European Parliament, was a human rights lawyer. It was Professor Vital Moreira from Portugal, Coimbra. And of course, he had a very strong view. By the way, he did a little bit the revolution in Portugal, so he was quite old, but he knew a little bit what dictatorship was about. And he had a very strong feeling about information, democracy, these kind of things. And Vital was really an interesting guy, still alive, started to attack the European Commission. Say, no, you cannot work just leaving the Parliament in the backseat as it used to be that time. You need to inform us. And all the debate became on, let's say, two levels. First, how much information should the Commission give to the Parliament concerning current treaty negotiations on trade, being the most important competence of the European Union? And that we're now negotiating with the United States and other countries. So the European Commission wanted to keep it rather almost secret, because there were many things which were under negotiations. The second point was the human rights clause. And the human rights clause at that time wasn't that popular at the level of the European Commission, but as you can imagine, today it's clear, was extremely important for the European Parliament. So in this mechanic of the system, we had the European Parliament growing in power and asking, pretending actually more and more, to the European Commission, who is the one who negotiates, of course, the treaties, to insert more and more human rights clauses and, of course, make them an essential clause in trade agreements. Now, that was not at all straightforward, and even today, we have people with doubts about it, because you may ask if you are, on the other side of the negotiation. If I'm a third country, you Europeans, and you say, we want to trade with you, but we need to know, we need to talk about your human rights situations on the ground and about your democratic process. Yeah. Very strange speech at that time, and even today it's a very strange speech, because the normal answer was, why should you be interested in my domestic affairs if I'm talking about access to the free market? Access to your market as well access to my market. Let's talk about business, let's not talk about trade. As you can imagine, at the same time, the lobbying by multinationals behind it was extremely strong, and multinationals have a lot of power in Brussels. Not many functionaries of the European Commission are listening to me, but in any case, that's my personal view of the scene, which is quite realistic. So the Council didn't have a strong interest in putting human rights clauses too, because the Council is the voice of governments. And the Council had, of course, bilateral powers to authorize these negotiations. And after a vote by the European Parliament, as you know, decides on the conclusion of the treaty. But all in all, and make it a long story short, I would say that the European Parliament was the real hero in this human rights clause into trade treaties. A second debate, which is more recent, which I point out to you if you are working on these topics, of course, is the relationship between human rights and sustainability or sustainable development goals. Now, you can look at it in two opposite ways. In one way, you could say, well, fantastic, human rights have expanded now to embrace sustainable development goals, which is, let's say, the more optimistic view. But if you remember what I told you about a little bit the history of this debate, you may take it also on the opposite way and say, well, if you water down human rights into too many things, like the sustainable development, which is fantastic, but it's too much, which is something which we saw when we were defining human rights. How many human rights are we talking about when we are negotiating a trade deal between two countries? Are we talking about the number of holidays of workers, seriously, or aren't we talking about the right to life? I mean, other, the famous fundamental rights which are contained in the International Covenant on Civil Rights. Now, 20 years ago, it was already the perception of the risk that when you move from the International Covenant on Civil and Political Rights, 1966, to the International Covenant on Economic, Social and Cultural Rights, since 1966, you have an immense field that you have to work with, which probably is too much. So I'm pointing that out because, as I said, you may be enthusiastic about the relationship between human rights and sustainable development goals, SDGs, but there's a certain backlash on the other side because it becomes too big. It becomes almost nothing. Now, at the third level of sorry, I have to move forward, but I can leave my PowerPoint. It's much more detailed. I want to, since you're tired, I just want to provoke your thoughts, bringing in some practical issues. Another, point of discussion, point of reflection for you is how far can the common commercial policy go? Well, once again, before the Lisbon Treaty, I wouldn't say that it was easy, but it was rather easy because we were just talking about trade. Now, today we're talking about trade, foreign direct investment, and intellectual property rights. A lot of stuff where human rights have a different impact. Clearly a different impact, because if we're talking about foreign direct investment, I think Francisco spoke about it before, so I'm not touching that. But if you're talking about that, you are challenging multinationals on the ground. Who's responsible for that? Is the European Union responsible for what a foreign multinational does in Italy, for example? Well, if you do a free trade agreement with a strong investment clause and human rights, well, that could be one of the consequences. We don't have it yet, by the way, but it is something interesting. If it's intellectual property rights, once again, the impact of human rights becomes a little bit different than a simple trade, because we've seen it during COVID time. You will work on human rights as part of the essential clause, or rather, sorry, of the fundamental exceptions of the implementation of the treaty. Article 20 of the GATT, where you have the public policy exception, you expand it and you put their human rights inside that. And beyond that, if you work with human rights and trade at the European Union level, you have to ask yourself a fundamental question, whether or not is it still an exclusive competence, that's Article 3, the treaty, or rather it is a mixed competence. Now, if you look at the different trade agreements that we have in place, by the way, not so many, because you find them easily on the website of the DG Trade. There's a lot of talk about not many agreements on the ground. But if you look at them, you will see that after the famous Singapore opinion, investment issues are considered to be mixed competence. And if you have a mixed or a shared competence issue, then you will have to wait also for the ratification of 27 member states, which basically makes the treaty something for our grandchildren. Because, these are the practical issues that you have to tackle as a practitioner, an academic, when you're dealing with human rights. I will say that I'm not that pessimistic, but, we need to talk about these issues with with feet on the ground, because otherwise we risk to make a fantastic philosophical debate or a debate which said that human rights are useless, which is not at all, of course, the case. Now, another important theme, and I will sum up after this theme, is what do you do as a European Union if the other state is in breach of human rights? Now in 20 years, remember, but if we had Vital Moreira as a president of the European Parliament, I would assure that he would, point his, he would crack the table and ask reports by the Commission and call the president, call Ms. van der Leyen and the others to explain the European Parliament. But that's not the case anymore. And if you look at the way in which the European Union may react to a violation of human rights by a third country, which is quite possible, especially if you expand the human rights to a very large catalog of rights, the reaction can be, let's say, summarized into the following. But first, you suspend the treaty. How many times have we done that? Probably once. Well, I think there was only one threat with South Korea, because South Korea was not agreeing on the social standards. And 2 years ago, the Trade Commissioner threatened South Korea of suspending the treaty. Didn't happen. But the second reaction would be trade defense. That's certainly theoretically possible, because if you're violating a trade agreement, then you may, counteract with trade defense. Of course, I'm speaking about the general framework. Never did it. A further weapon in case of violation, of course, I'm talking about gross violations of rights, would be that of using smart sanctions. And that's a little bit the line which is prevailing today in Brussels. So, well, instead of hitting an entire country, why don't we separate those 2-3 ministers who are responsible, can be responsible for these really gross human rights violations, and we use smart sanctions. denial of visa, freezing of assets, and so on. That's an entire new philosophy story. Certainly new. So smart sanctions basically amounts to, identify the bastard and hit him or her because he's violating the human rights contained in a trade treaty between the European Union and their country. Or, and that's probably what has been used mostly, and I can certainly testify a number of applications of that, you use soft power. Once again, if you are a human rights, say, you would not be satisfied with that. If you are, let's say, an international lawyer is a little bit with experience, would say, oh, soft power, why not? What do you do with soft power? Well, soft power would mean that first you would open up a political dialogue, and that's exactly what happens most of the times. Political dialogue means that the European Commission and the government on the other side meet and discuss what has been done, what can be done to improve the situation so that the treaty will not be suspended. Or even use European education to, propagate human rights. But once again, this, presupposes the idea that human rights are accepted by everybody in the world, and we are happy with that. Now, I was the one who created the human rights program in Arab countries. I can tell you that's a difficult exercise, but it's not impossible. But it's not impossible because the first reaction that you have on the other side is we are perfectly okay with human rights, but you have to assure me that it's not European human rights imposed in our countries. And I answered, it's not European human rights, it's universal human rights, United Nations, and so on. Well, the second answer that you get, my gosh, was to say, all right, so if it's universal, global, I would say that we will apply human rights, but after the Sharia, is the holy law of the Quran and religion law. Kind of difficult to navigate about that. So after these kind of approaches, you have to think and perhaps also appreciate the work done by the Commission in Brussels with this political dialogue, because otherwise, if you don't speak, it becomes, of course, very, very harsh. Now, all in all, and once again, I don't want to use much of your time, let me just focus attention on a skeleton of issues that you find in human rights clauses that are used in EU trade policy. Well, the first point is whether or not a human rights clause must be included in a trade treaty. Now, once again, if you want to be dogmatic and consistent, we'll say, yes, we want it for everybody, but then it means that you put it also in a famous TTIP with the United States, that you put it in the CETA with Canada. Well, I certainly would say yes, but not many people would say yes. No, it's impossible because a human rights clause work only with countries whose human rights record is not so high, which is already a judgment of value because this kind of ranking, as for university ranking, is done by someone and everybody's criticized, right? So if you want to be, serious and global, real cosmopolitan in your mind, you have to accept that. But if you believe that human rights must be propagated are a good thing, we should have a human rights clause in every trade treaty of the European Union. And this is the first question mark. In Brussels, they would say with some countries, yes, with other countries, no. And that's probably not the ideal situation. The second point is wording. If you compare different human rights clauses in different treaties, now on the website, also you find different reports that have been produced recently on that, you would see that the wording is different from, once again, country to country. So certainly Myanmar doesn't have the same wording than South Korea. And once again, this could be a matter of criticism, because this brings very quickly the problem of double standards. Is it one standard for all, or is it double standard in the sense that, you know, with some countries we have to be stronger, with other countries we have to be weaker? I was surprised that some people at the European Parliament, after legendary Fabrizio Marrella, of course, was saying, you know, we can keep strong with small countries because we are stronger and we want to impose human rights, and we have to be, you know, we have to accept the situation with other countries which are on comparable sides, like China, United States, and so on. Doesn't seem a good policy to me, but this is something which, you know, from time to time happens in the European institutions. The third point, which has to be noticed, is what mechanisms do you create in EU trade agreements dealing with human rights? Is it the same mechanism that you use for checking compliance of trade? Of course, you know, if you have studied a little bit of human rights, I mean, that's an entire field. It's not so easy. You can know trade and human rights, but you have to study 20 years. So once again, the avenues of choice, policy choice, would be make a specific human rights committee to check the human rights clause, different from, you know, the trade committee, which is normally established to check the trade obligations. But then you have to speak about the powers. You don't see much in different treaties about the powers of these mechanisms. Should they terminate the treaty? Once again, if you are an international lawyer, you start trembling. Wait a minute, the human rights guys there terminate the treaty by the European Union and a third country? Shouldn't be the European Union talking about these things with a third country. That's very delicate stuff. So theoretically, once again, well, it's quite simple. In practice, there's a lot of ambiguity, and of course, more discussion is certainly needed. So, if you look, I had prepared for you some examples. Here is, if you look, for example, the comparison table here in yellow, you will see that the wording is different between Vietnam, Canada, New Zealand, Australia, and Singapore. But the pattern is almost the same. One important issue here would be that of making reference to human rights treaty. But, and here is a big but, do you make reference only to human rights treaties in force between the two countries? Or do you want to do a fantastic round one, as we do in private international law, and you start incorporating in a trade treaty between the European Union and a third country, human rights treaties which are not in force in the two countries? Fascinating as an international lawyer. They do it from time to time. I don't know if they really understand what they're doing when they do this, but it's still a big question mark, because it means a very strong obligation on the side of the other country, because it hasn't ratified the human rights treaty. It happens, sorry. Look at the genocide conventions. It's very fashionable today. You find states who have made reservations in genocide conventions. So, after that, you can expect anything. So here it means that to trade with the European Union, you must comply with the human rights clause, saying that you must comply with a human rights treaty which you don't have ratified in your country. That's very strong, a strong step. But it happens. As you look at the anatomy of these human rights clauses, you also may find issues concerning proportionality, which, as you can see, sometimes they are present, and it makes sense because how much human rights violations should we have in order to suspend a trade treaty with the European Union? But normally, we would say you need gross violations of human rights, which is very high level of madness in the country. Small violations, therefore, would escape this kind of test. And a final consideration would be whether or not in a trade agreement, since now 2023, you need to talk also about investment issues, would you consider to talk about corporate social responsibility in this kind of agreements? Now, that's a matter for new generations, trade agreements of the European Union, but, having studied that matter for almost 20 years, I gave a course at the Hague Academy International on that. I can tell you that if you say to a country that the foreign investors in your territory must have corporate social responsibility, that's not really effective, because corporate social responsibility is the famous second pillar in the guiding principles on business human rights, which means that it is the company which has to, organize itself in order to anticipate, operate due diligence, minimize human rights impact on the ground, and so on. So far, even though the European Parliament, that's another very important weapon that the Parliament has frequently asked the European Commission for so-called human rights impact assessment. Well, it's extremely difficult to see whether or not foreign investors use CSR because of a trade agreement between the European Union and the home state. That's a completely different level, and it should be undertaken different. I'm saying that because the European Parliament in 2011 adopted a specific resolution asking the Commission to insert corporate social responsibility clause in the trade agreements of the European Union. So let me conclude with some questions and possible answers. Let's make a balance sheet and see if all that makes sense or not. Of course, should we have human rights clauses in trade agreements? As I said, the answer is controversial, but, honestly speaking, if you want to sustain human rights around the world, and you have to do something, well, they seem to be in a good place only because the European Union can, let's say, negotiate about trade. It doesn't have any other topic where can strongly negotiate and making his point of view being heard. By the way, this idea of having human rights clauses in trade treaties, which I could say it's rather naive, let's say, European Union institutions, but in a positive way, is understood in a completely different way by other countries. So some US scholars, for example, would consider human rights clauses in trade treaties still a good thing, but in order to, trigger an unfair competition, an anti-dumping investigation, and punish the country because that. So the perspective is different. Perhaps in the European Union, still people wants to spread human rights in the world, but you may have a different perspective, which is a more economic perspective. Say, if you don't respect human rights, you are producing with in a way which is unfair in competition law terms to my business, and therefore you should pay a price for that. That's not the European approach, but it is something which is in the air, at least in the discussions. The second point is that we may promote human rights with trade because we want to change trade. We want to unify trade with non-trade values. But that's something that the Union has certainly, I guess, civil countries in general, I could say, have understood and promote in various ways. It's the famous distinction between commercial law and labor law that we have in our legal systems. But that's something that we may have. Other countries do not see that as important. I already mentioned the fact of the risk of human rights clauses becoming sustainable trade clauses. I guess tomorrow there will be another Ukraine. So I'm launching some hints for discussion. Once again, it could be a positive way, but can also turn around on the other directions and water down the entire issue, because the problem is the triggering mechanisms and the consequences of the triggering mechanisms, and that's really a dilemma. The sixth issue is who will monitor compliance of these trade agreements. And as we said, we may have different views. We may have human rights bodies within trade compliance bodies, which is quite awkward, but still it's possible. And when we're talking about sanctions, that's a new trend. As I said, the new trend would be to perhaps either, if political dialogue doesn't work, well, try to discuss the better suspension of the treaty, but also use the smart sanction weapon in order to target those specific individuals who are harming human rights in the country. Now, final thought, this is a fantastic discussion, a fantastic topic, which will be with us for the next 20 years, I'm sure, but it's not really in the rooms of China. And that's another danger for human rights, not because China is dangerous, but just because China doesn't consider that human rights should be matched with trade. And in fact, the trade treaties that negotiating with African countries and other countries do not have human rights clause. So it's a philosophical perspective changes. Perhaps Chinese are thinking like we were thinking 30 years ago, but being very powerful. And if you are, in a country, let's say in Africa, you have the European Union offering access to market with a lot of obligations coming from human rights that nothing to do with trade. And we have Chinese coming there with another fantastic treaty talking about trade and not human rights treaties. Well, that's a competition in terms of human rights, which is something to be considered. And therefore, in the long run, perhaps this fantastic history of matching human rights with trade will not be again in the rooms of the European institutions. So my conclusion is better to talk about it, better not forget about it, because human rights are fundamental values of the European Union. But let's not forget that the European Union is not alone in the world. And that's going to be the risk if you just look at this from an inward perspective. You have to look at it in global perspective, but there are global perspectives which are different from the ones that we consider it as straightforward as I tried to present. So thank you very much.
If you have any questions, you have to ask for support. Especially in time.
On Albania, you will have. Yes.
So how do countries that have regular human rights negligence be treated by international law?
How do we yeah.
That have might be treated in international law when they have this comparative. It's comparative advantage on the basis of negligence.
Fantastic question. Yeah. You can see the difference. In fact, when you compare European Union law with international law, in international law, you don't have this matching of trade with human rights. And so you cannot say the Chinese are violating international, because they would answer as in international law, the answer seems correct. Trade is trade, human rights is another treaty with different human rights mechanisms. It's like, the discussion within the WTO of social clauses or social rights and trade in the WTO. they have been even trying to propose that the WTO complies with the International Labour Organization standards. The answer has been absolutely not. They are two separate systems, and therefore you have different treaties, different mechanisms. Remember, I asked a question in London some time ago. I was trying to say, but different treaties, different mechanisms. So if you violate one treaty, you know it because the mechanism tells you, but you cannot match one mechanism with the other. That's not how we see it in the European Union, but we have to respect that in international law, the two issues are quite separate. The WTO doesn't talk about it, and for example, the World Customs Organization, because that's also important. Talk about products made in a certain countries violating, for example, human rights. Is there a customs law issue? The answer is not at all, because customs follows customs law, and human rights is another story. So I would agree with you that it's awkward, but unfortunately the answer in international law is two different planets. Right?
Any other question?
Yes. Okay.
My question, what is the mechanism used by the EU with China trade?
But we have only one international agreement on investments, which is not even enforced. So never had the chance to use it, but there have been discussions about it. And what I know is that there's a lot of political dialogue. And this political dialogue is the European Commission sending, people in Beijing. 1 year, another year is Chinese, civil servants coming to Brussels to speak about, how China should implement ILO conventions. And Chinese very happy to discuss about it, but they say, that's a different story. I mean, why should we talk about it? I will talk about it in Geneva with the ILO. Why should you, in Brussels, be interested in my democracy or my compliance with the ILO conventions? So it's a tough game. And it's been on and on for at least 10 years, not once. Okay, so I thank you very much for your attention, and good permanence in Pisa.